Wealthy families use advanced asset protection structures, such as a trust, to separate ownership from their personal estate, define control, and maintain continuity across jurisdictions. Without a trust structure, assets held in different countries often remain legally tied to the owner. And when a legal claim or succession is triggered, a lack of structure can create serious issues to the wealth that you have built over time. A properly structured trust introduces a clear ownership layer above the assets, support the governance and documentation that banks and courts recognize. My name is Shiraz Vahid and I'm the co-founder at Lepidus Wealth. And in this video, I'm going to explain the top 10 trust jurisdictions used for asset protection and estate planning, how they differ in legal strength and practical use, and how to position them correctly within a multi-jurisdictional structure. Let's start with number 1 on the list, that is Cook Islands Trust. The jurisdiction is widely known for strong legal protection. Foreign judgments do not automatically apply, and any claim must be brought into the Cook Islands courts under strict legal thresholds and time limits. This increases the cost and complexity for any claimant. The structure works only when it is set up before any known risk. With proper trustee and documentation, it creates a high level of legal separation. The next jurisdiction on the list is Nevis. Nevis plays a slightly different role. It offers strong statutory protection, especially for creditor claims, and is often used with underlying companies. It provides a balance between legal protection and practical setup. It relies more on legislation rather than case laws, which affects how it is used in structuring. Nevis is commonly used where both protection and flexibility are required, but timing and intent still need to be correct. Number 3 on the list is Cayman Islands. The Cayman Islands Trust focuses more on institutional capabilities. It is widely used in investment structures, private equity, and family offices. The legal system is stable and based on common law, which banks and counterparties understand well. It allows for controlled flexibility, so you can retain influence without losing legal separation. It works best when the structure needs to interact with investment platforms and global financial systems. Number 4 on the list is Guernsey Trust. Guernsey is commonly used for long-term continuity. It has a mature legal system, strong regulations, and consistent court interpretations. Trustees operate under clear obligations, which supports structured governance. This is useful for multi-generational planning, where control needs to pass in orderly way. Banks are comfortable with Guernsey, which helps reduce friction in setup and administration. On number 5 is Guernsey. Guernsey operates in a similar space but offers more adaptability in certain structural scenarios. It is well established with strong legal framework and experienced trustee. The difference is often in how flexible the structure can be when dealing with complex family arrangements or cross-border interest. Guernsey Trust is frequently used when governance needs to be customized, especially when multiple asset class or jurisdictions are involved. It maintains regulatory credibility while allowing practical structuring. Next on the list is Isles of Man. A trust in Isles of Man is often used where operational efficiency becomes a priority. It provides a stable, well-regulated environment with strong links to insurance and investment planning structures. This makes it practical for long-term administration, particularly where structures need to interact with financial products or ongoing investment strategies. It is usually used for structures that need to function smoothly over time, especially where administration and investment planning are important. From a banking perspective, it is well understood and widely accepted. Number 7 on the list is Singapore. Singapore trusts become relevant when geography and regulations intersect. For families with assets or operations in Asia, it offers a strong legal system, high-quality banking, and a reputation for regulatory discipline. Trusts here are transparent and compliance-driven, supporting institutional relationships while requiring ongoing oversight. Its strength lies in alignment with financial infrastructure and regional access. It is especially helpful where decision makers, assets, and banks are all within Asia. Next on the list is Dubai or UAE. Trusts in the UAE are established within financial free zones such as DIFC and ADGM. Both offers modern trust regimes with clear statutory frameworks, recognized trustee, and defined fiduciary duties. Their courts follow common law principles, providing legal clarity and consistency. Usually, these trusts are used to define succession, control, and governance while separating ownership from your personal estate. Because these regimes are regulated and well documented, banks and counterparties are increasingly comfortable working with them. This makes the UAE a practical jurisdiction within a broader cross-border structure, especially when assets are located across Middle East, South Asia, or Africa. On number 9 on the list is United Kingdom. The UK remains one of the most established trust jurisdictions. Its legal system is widely recognized and its principles underpin many other jurisdictions. UK trusts are often used where legal clarity and court recognition are important, particularly for UK connected assets or beneficiaries. However, tax exposure is a key consideration, as inheritance tax and other rules depends on domicile and residency. Structures must be carefully aligned with your personal tax position. And the final jurisdiction on the list is Gibraltar. Gibraltar Trust is often used in cross-border structures, particularly in cases where there is an interaction between the UK and European assets. It operates under common law and provides a balance between regulation and flexibility. While not as prominent as some other jurisdictions that we have discussed, it can be effectively used when it is part of a wider structure, usually as a supporting layer rather than a primary jurisdiction. As you look across these jurisdictions, the distinction is not about ranking them in isolation. Each one serves a different function, from legal resistance to governance and banking alignment. In practice, clients with the most effective structures usually combine jurisdictions. A trust may provide legal separation while underlying entities hold specific assets. Banks assess the structure as a whole, focusing on governance, documentation, and purpose. Ultimately, asset protection and estate planning depends on how ownership is structured and how the framework operates across jurisdictions over time. Now, if you want our help and would like to set up a trust or a foundation in any of the jurisdictions that we have just discussed, you can request a personalized asset protection plan by clicking the link in the description below. That's it for today, and I will see you in the next video.